Morning, friends. My name is Umesh Rao. Today's subject is precedents. In this class, we are discussing meaning of precedents, when precedents becomes weakened or destroyed, kinds of precedents, and advantages of legislation over precedent. What is the precedent? Precedents are known as judge-made law in England. In England, it is known as judge-made law. Why? Why precedent occupies high place in English system or English society? English judges occupied a very high position in the country. They are experts in their law field and their decisions enjoyed high reputation. Some accepts the view that judicial precedents is a source of law. Some writers are the view that judicial precedents are not a source of law. So, precedent means it is the decision of the superior court which is binding on lower courts. Courts are bound only by the decision of the higher court, not lower courts or courts of the equal rank. Precedent is the second important source of legislation. What is the nature of precedent? Precedent is purely constitutive and not abrogative. That means judicial decisions can make a law, but it cannot alter it. Judges cannot substitute their opinion for the established rule of law. Their function is very limited. They have to follow the settled law. See why precedent is recognized? Because people think judicial decision is presumed to be correct and people respect this decision of the judges. People presume that what is delivered in the judgment must be taken for established truth, and it is true. In fact, the practice of following precedents creates confidence in the minds of the litigants. Because of precedents, law becomes certain and known to all. It is conducive for the social development. So, administration of justice becomes even handed, fair, because judges are experts in the study of law. When the law is settled, it gets into textbook, and these textbooks are guide to practitioners. How the president plays an important role in lawmaking. So, for example, you take some case laws. Ashby versus White. Here, plaintiff was a qualified voter, defendant was the returning officer. Defendant wrongfully refused to take the plaintiff's vote. Plaintiff's legal rights are deprived. The court held that election officer is liable to pay damages for not accepting the legal right. This case led to the principle of injurious sine damnum. This became a precedent for all future cases. We will take up another case, Dinog versus Stevenson. The plaintiff went to a cool drink shop along with his girlfriend. They purchased a ginger bottle of black color. She consumed and felt uneasy and started vomiting. It is observed that decomposed body of snail was found in the bottle. Plaintiff sued the manufacturer for his negligence. House of Lords ordered the manufacturer to pay compensation to the plaintiff. This case paved the way for consumer rights. This became precedent for all future cases. Another case we will take up, Ryland versus Fletcher. Fletcher has a mill. He has to supply water to it. He employed contractor to construct a reservoir for storage of water. There are old disused shaft and passages under the reservoir. Employees did not properly fill these shafts and passages. The water overflowed from the reservoir through disused shafts and entered into coal mine of Ryland. Ryland sued for damages. Fletcher proved no negligence on his part. The House of Lords held that the defendant is bound to keep at his peril and therefore he is liable, and this paved the way for strict liability. Another case is the Bhopal gas leak case. In this case, it is held that person is liable without any fault for his irrespective of any consideration of intention or negligence on his part. It is not necessary for the injured party to prove any intention or negligence on the part of the injuring party. This case laid down the principle of absolute liability. But precedents may always not force to some cases. Precedent becomes weakened or destroyed under peculiar circumstances. The operation of precedent is based on the legal presumptions that the judicial decisions are correct. Means we are presuming that all the cases decided by the judges are correct. Matter once decided is decided for all, once for all. However, there are exceptions. There are circumstances which destroy the binding force of the precedent, as detailed below. In all the cases, precedent will not be taken into account. For example, first one, abrogated decisions. The decision of the higher court, is not binding if the statutory law is inconsistent with its subsequent enactment or it is overruled. If a decision is wrong or irrational, it may be abrogated by a subsequent decision of higher court. Sometimes higher court reverses the decision taken on appeal stage. Sometimes higher court declares the precedent was wrongly decided and is not followed. The decision of the higher court, for example, decision of the high court is not binding when the same decision is reversed or overruled by a higher court or supreme court. So when reversal of decision takes place, when the same decision is taken on appeal, it is reversed by the appellate court, then reversal of decision takes place. When overruling of decision occurs, when the higher court declares in another case that the precedent case was wrongly decided and it is not to be followed, overruling is the act of the superior authority. Now, affirmation or reversal on the different grounds. Sometimes higher courts either affirms or reverses the judgment of the lower court on different grounds. So, decision either affirmed or reversed on another point, then it destroys the binding force of the precedent. For example, a case is decided in the court of appeal on ground A. Party goes on appeal to the House of Lords or Supreme Court. Supreme Court or House of Lords decides it on the ground B. Supreme Court did not discuss the ground A at all. It means judgment of the lower court is affirmed on different grounds, then it destroys the binding force of the precedent. Ignorance of statute. A precedent is not binding if it rendered ignorance of any statute. It is not binding if the court had the knowledge of the existence of the statute, but it failed to appreciate its relevance in the matter due to negligence or ignorance. Inconsistency with earlier decision of the High Court. A precedent loses its binding force if it is inconsistent with the decisions of the High Court. For example, Court of Appeals decides a case of in ignorance of a decision of the Supreme Court. Precedent is not binding either on itself or on the lower courts. In this case, decision of the Supreme Court is binding. Inconsistency between decisions of the same rank. The court is not bound by its own previous decisions that are in conflict with another decision. The courts are free to choose between the conflicting decisions. Precedent sub silentio are not fully argued. It is a technical sense that a particular point of law involved in the decision is not taken into account by the court. Sub silentio means when the point of law involved is not fully argued or not taken into account by the court. So, when a particular point involved in the decision is not taken notice and it is not argued by the lawyer, court may decide it in favor of one party, whereas all the other points has been put forth, decision may have been taken in favor of another party. However, Supreme Court observed that binding force of a precedent does not depend on whether a particular argument was considered there or not. Now, decisions of the equally divided court. In these cases, judges of the appellate court are equally divided. Where an appellate court equally divided, the practice is to dismiss the appeal. This problem doesn't arise nowadays because the benches are constituted with uneven number of judges. Erroneous decisions. The decisions which are founded on misconceived principles. The rule that courts are bound by the decision of the High Court, higher courts, in some cases by their own decision, even though wrongs. What is the erroneous decision? Decisions founded on wrong principles. Decisions founded on conflicting with the fundamental principles of common law. The court is free to disregard these decisions. Kinds of precedents. One, authoritative precedent. It is a legal source of law. It comes from the superior courts and it has to be followed by the subordinate courts. So, for example, the President of the Supreme Court of India is authoritative for all courts in India. It must be followed by the inferior courts, whether they approve it or not. The judicial president of the High Court of Karnataka is the authoritative president in relation to other subordinate courts in Karnataka. Next one is persuasive president. Here, judges are not under an obligation to follow. For example, foreign judgment. Judgment given by a foreign court is a persuasive precedent. In this case, judges can pursue, interpret, and take the assistance of persuasive precedent. For example, decision of the High Court of Karnataka in relation to the Andhra Pradesh High Court is a persuasive precedent and it has no legal claim. Absolute precedent and conditional precedent. See, authoritative precedents are divided into two kinds. One, absolute authoritative precedent and conditional authoritative precedent. Absolute precedent. In this case, absolutely authoritative precedent, they have to be followed by the judges even if they don't approve it. Conditional precedent. In this case, authoritative precedents having a conditional authority, the courts can disregard them under certain circumstances. Ordinarily, they are binding, but under some certain circumstances, they can be disregarded. What are the circumstances? When the court's decision is wrong. Second, the decision is contrast to the law and reason. Third one, there is already an existence of an established rule of law. This decision does not follow it. So, conditional precedent can be disregarded either by dissenting or by overruling. Overruling means decision of the superior court in connection with the decision of the lower court, inconsistent with the decision of the lower court. Dissenting means court declines to follow the precedent. It lays down the law in a different sense. For example, Decision of the single judge of a high court is only conditionally authoritative and it may be dissented by another single judge, or it may be overruled by a decision of division bench. If one division bench dissents from another division bench, the procedure is different. The division bench is the final court of appeal in an Indian high court system. The full bench can overrule a division bench decisions. So it means the courts of superior jurisdiction can overrule the decision of the subordinate courts. So it means equal rank courts or coordinate courts. When there is a conflict between two coordinate courts, dispute can be solved only by the superior courts. So now another is original precedent and declaratory precedent. Original precedent is one which creates a new rule. It is very small in number, it is new rule. For example, the case of Bhim Singh versus Jammu and Kashmir government. Bhim Singh was detained by Jammu and Kashmir police. Supreme Court ordered the state government to pay rupees 50,000 compensation to him. Another is declaratory precedent. It is one which merely application of already existing rule of law. For example, Bhavasagar was a merchant in Hyderabad. He was arrested by the police illegally. Andhra Pradesh High Court ordered the state government to release the merchant and pay him rupees 20,000 towards compensation. This case of High Court of Andhra Pradesh followed Bhim Singh versus Jammu and Kashmir case. So, declaratory precedent merely follow the original precedent. So now advantages of legislation over precedent. Legislation and precedent both are the sources of law. Legislation is both constitutive and abrogative. Precedent is only constitutive. By legislation, we can abolish the existing law. Precedent, we can produce a new law, but we cannot reverse that which is already a law. Legislation is necessary for the growth of the law and its reform. Legislation is based on the principle of division of labor and noted for its efficiency. Legislative and judiciary functions are separated. Legislation attends the function of legislation. Judiciary attends the interpretation and construction of law. In the case of precedent, function of the legislation and interpretation are combined. So legislation satisfies the requirement of natural justice. Law is declared in the form of legislation and the same law is enforced by the courts. Law is declared to the people. If they want to violate, they will be punished. However, it is not in the case of precedent. There is not a formal act of declaration of precedent. It is applied as soon as it is made. Precedent applies retrospectively. Legislation is independent, precedent is dependent. Legislation makes rules for cases that have not risen. It is not in the case of precedent. Precedent must wait till such time it is brought for a decision before the court. Legislation is superior to precedent and legislation is brief and knowledge. Precedent means case laws. Case laws are huge and growing, very difficult to search. Thank you.